Good afternoon. My name is George Pattis, and I'm an assistant U.S. attorney in Dallas and the co-chair of the 2022 DAYL Trial Skills Bootcamp Committee. On behalf of the committee and the other co-chairs, welcome. Today's CLE on the nuts and bolts of depositions is the first event in our three-part series on the fundamentals of trial skills, and all of our programs this year, all three, will be based on the same hypothetical that will be used today. So keep an eye out for dates of our summer boot camp on witness examinations and objections at trial, and our fall CLE, which will be on expert depositions and motions to exclude. CLA information for today's program will be provided later in the chat. Now, let me introduce our distinguished panel of speakers and demonstrators before turning this over to the moderator, Judge Martin Hoffman. First, Manuel Bareilles. Manuel Bareilles is a litigation partner at Vincent & Elkins' Dallas office, where he also serves as the firm-wide hiring partner. Manuel's practice focuses on complex business disputes, government and internal investigations, as well as representing financial institutions and their directors and officers facing regulatory investigations and enforcement actions. Manuel joined Vincent & Elkins after completing a clerkship with Raymond Fisher of the U.S. Court of Appeals for the Ninth Circuit. He has been named a top Latino lawyer by Latino Leaders magazine, one of the 20 extraordinary minority lawyers in Texas, and a best lawyer in Dallas for the past 3 years. He also currently serves on the Texas Supreme Court Advisory Committee. Heather Long. Heather Long is a personal injury trial lawyer here in Dallas, where she owns and runs her own firm, Heather Long Law. She serves on the board of directors for both the Texas Trial Lawyers Association and the Dallas Trial Lawyers Association. Heather has been recognized as one of the best plaintiff's personal injury attorneys in Dallas by U.S. News and World Report, and she has presented on numerous topics, including responsible third parties, opening statements, and what it's really like to be a civil litigator for our organization, the DAYL. Last of our panelists is Shane Reed. Shane Reed is an assistant United States attorney in Dallas, where he has primarily worked on civil cases. He is also the author of several litigation textbooks that have been adopted by top law schools. His textbook, Winning at Deposition, received the Association of Continuing Legal Education's highest honor for a textbook. And his book, Winning at Persuasion for Lawyers, received the honor of a Kirkus Star Reviewed, which is given to only 2% of the books reviewed. He is a nationally recognized expert who has trained lawyers throughout the country on persuasion, depositions, and trial skills. Our moderator today will be Judge Martin Hoffman. Judge Martin Hoffman was elected in November 2006 to the bench of the 68th District Court, which specializes in civil jurisdiction. Since then, Judge Hoffman has been honored as the Trial Judge of the Year for 2018 by the Dallas American Board of Trial Advocates, an Outstanding Jurist by the Dallas Women's Lawyers Association, the Honorable Cleo R. Steele Committed Mentor Award by the J.L. Turner Legal Association, and repeatedly as an Outstanding Mentor by both the Texas Young Lawyer Association and the DAYL. He has also been elected 4 times to the Dallas Bar's Board of Directors. Before taking the bench, Judge Hoffman practiced as a civil litigator for 13 years. Now, let me turn things over to Judge Hoffman. Judge Hoffman.
Thank you, George. Today's program will begin with a panel discussion on preparing for depositions, followed by 3 demonstrations, and each demonstration will be followed by a short panel discussion. So it's a little bit different format than we've done in the past. Before I launch into that, I do want to thank all the members of the committee that worked so hard on putting this program together and this entire year's program together, especially George, you've done a wonderful job, and Barrett, who put together the hypothetical, and all the other folks who helped put this together. You guys have done a great job. The demonstration we're going to be hearing today will be based on a 2022 hypothetical, which I will summarize briefly for those who may not have had a chance to review it. Barry Cadshaw's hit TV show, and thus featured Mr. Large being thrown from his kiloton Pilates machine, resulting in his tragic and dramatic death. The day after the episode aired, Kiloton's stock price plummeted 39%. The hedge fund run by Barry's spouse, Tiberius Rex, made a fortune on an enormous short position on Kiloton stock. Kiloton has sued Barry and Tiberius for numerous claims, including defamation and unfair competition based on the show's portrayal of the Kiloton Pilates machine killing Mr. Large. Today's demonstration will feature examination of hedge fund manager Tiberius Rex, Kiloton's designated corporate representative, and showrunner Barry Cadshaw. Co-chair Barrett Armbruster will portray each witness. Please note that for teaching purposes, our demonstrators will often be modeling what not to do. And I wanted to point out to everyone watching this, this is not how they normally approach depositions, so please don't hold this against them. But first, let's briefly talk about preparing for depositions. Let's talk about, Heather, if you want to give us kind of an idea of what you do to prepare for depositions.
Hi guys, good afternoon. I think preparing for depositions, it is a continually evolving, at least in my experience over the last many years, practice to figure out what works for me. So when I'm preparing to take a deposition, I do things a little bit differently than a lot of people. I have first my card that is in front of me at all times. It gets taped on a desk and it has my key points. And it's just the big subject matter topics that have to be addressed, so that if you're going through your deposition and you get meandering, I always know, did I cover this? I don't want to miss these things. And the way I compile that is based on my jury charge, which I know everybody tells you, write your jury charge when you start your case. I'm going to tell you, write your jury charge when you start your case. My second little cheat sheet of dates, people, places, any kind of date that I need to have a quick reference, I have that right next to it. And then, unlike a lot of people, I don't write out questions. I write out kind of segment cue cards. This is something that I picked up while working for Charla Aldis. I cannot claim it. A lot of times these cards are attached to a specific exhibit with a file folder, so that I just pull out the exhibit and I have my cards attached to it. Today, I'm not going to use any exhibits in this one. So that's my method of preparation. And usually a good rule of thumb is I spend about 2 hours of prep time for every hour of deposition I think I'm going to take in a non-expert witness, non-corporate rep situation.
Great. Manuel, can you tell us a little bit about how you prepare for depositions?
Yes, thank you, Judge, and good afternoon to everyone in attendance. I think Heather's advice is spot on. I don't want to repeat anything that she said, so I'll just add a few things to it. I also like to be pretty familiar with with any exhibits or hot documents. You know, obviously by the time you're sitting down with a witness, you will hopefully have a decent handle on the documents in the case, to the extent there are documents, and you will have identified ahead of time, and this is clearly preparation, what documents are really important for a particular witness. So I will also have those ready and have given some thought, either using cue cards or a notepad, to the specific issues that I want to address with a topic. The last thing you want to do in a deposition, because it burns so much time, is just have a witness walk through an entire document or a long chain of emails. So really spend some time before you sit down for the depo, knowing what aspects and what parts of the documents are really important and critical to the points you're trying to make, or answers you're trying to get out of the witness. So I would add that piece. The second thing is, and this is not always, you're not always able to do this, but in particular for lawyers who maybe don't have a lot of experience yet taking depositions, I think it's critically important to try and see if you can do some mock Q&A with a colleague, with someone who can act as the witness and give you a chance to ask some practice questions. And a lot of times you will learn that the way you ask a question might not be the best way to ask it, because of the answer you got during that practice session. Again, it's not always feasible, and you may not be able to, certainly you're not going to be able to do a full day mock, depo. But if you can do it, if you can spend 30 minutes or an hour even with someone who's relatively familiar with the case, another team member on the case, or even a paralegal, that can be really helpful, and you'll learn some things from that exercise that you might not otherwise have known until you were actually live in the deposition with the witness.
So Heather, you had 3 different cue cards you kind of used. You said there was, could you just summarize what those were? Because
Sure.
I
have
yeah.
my main key points. This is the table of contents for my deposition. It may not go in order. I have the order I think they'll go in. And then I have my cheat sheet of people, places. Like on this one, I don't know if you'd be able to see because, but it says, here's what these people are. And then it tracks the dates and it kind of tracks the company. It's just like that quick reference so that when you're in the moment, if you have a individual that's a person that's involved in the factual events that had taken place, you can just grab it and go, oh yes, that was Enrique Rodriguez over at Articus. Okay, that way I'm not fishing for names and the transcript is clearer.
And your last one was, I think, time was what was the last one?
Right, and the last one are what my kind of key points are, like my talking points for each of the key topics. A lot of times I'll have, my first topic today is going to be allies. Fair warning to Mr. Tiberius Rex there. And so I have my allies, and it just has like little jotted down key phrases for me about where I kind of want to go. And if I have exhibits that are going to be involved, they will be in file folders that are hanging at my side and have specific cards, but I know what exhibits go with allies and what I'm likely to use. And I also have them obviously ready on digital. So it's a lot of organizing. And I found this method helps me organize my thoughts about what way I want the deposition to flow.
Shane, did you want to add anything?
I think Heather and Manuel both have it. I like the idea of having your key topic. It's all about having themes for your deposition, and being organized is the key.
Great. Let's go ahead and turn it over to our first deposition. The deposition will be of hedge fund manager Tiberius Rex. It'll be taken by Heather Long and defended by Manuel Borellis. And again, this is not how they would normally, that there's going to be a bad guy, at least one bad guy at each of these depositions. Realize this is not how they normally take depositions, but I'll turn it over to you, Heather.
All right. And for purposes of the demonstration, we're going to jump in like we've already done the background, who you are, who you're married to. Tiberius is married to Barry Cadshaw, and they're both co-defendants in this case. So, Mr. Rex, your wife, Barry Cadshaw, would you describe her as a pretty successful in her recent endeavors?
Yeah, I think that's fair.
And her recent endeavors have, I imagine her success has made you proud, right?
Yeah, I'm very proud of my wife.
The two of you have also have become very successful over the last several years in your own right, correct?
Objection, Ms. Long. This question really is, we're not here to talk about Mr. Rex's success, I don't think. So why don't we move to the more relevant and pertinent issues?
Counsel, I appreciate your speaking objection. Let's keep the objections to form. If relevance is an issue, that's an issue you can take up with the judge. I promise you I'm moving along as planned, and I'm entitled to ask these questions of your witness.
Well, I'm just really trying to help you out because it's in the, it's mid-afternoon, and I told you I've got that flight I've got to make at 4:30. So
yeah, and I absolutely understand, Mr. Borellis, and I'm trying to, make this move along well enough for you, but the rules entitle me to the amount of hours that I have, and if this is going to take the amount of hours that it takes, and it will only go quicker if you keep your objections to form, and if your witness continues to answer, as he actually has been, pretty directly. So with that, let's turn back to subject matter now. Mr. Rex, you are the CEO of a hedge fund, Cowboy Capital?
Managing partner.
Managing partner, thank you. And that's a role that you have had during the course of your marriage while Barry has been making her own right in the entertainment and now in the fitness industry.
Yes, that's correct.
Some might refer to you guys as a power couple.
Objection, vague and ambiguous. Not sure where you're going with this, Ms. Long, but I don't think we need to talk about whether they are or not a power couple.
Well, respectfully, Mr. Bareilles, your clients are alleged to have both interfered with and collaborated to cause a billion-dollar company to fail. So I will be going into how they operate both as a team and how they have used their success and their collaboration in their very successful industries. I'm sorry if you don't like it, but that's the way it is. Turning back to the matter at hand, let's talk a little bit about your background, Mr. Rex. You're in the hedge fund business.
I think it's more accurate to say I'm in finance.
Finance. What's the distinction for you?
I don't just manage hedge funds. I also deal in other sorts of investment vehicles, whether it be private equity or other private investments.
Okay. And so you've been in the business, the finance business, as you call it, for several years now?
Since 2003.
And it's my understanding that you kind of got your start learning from a legend in the finance industry, a Mr. Gerhard Gladden.
Mr. Rex, hold on a second. Ms. Long knows that you don't need to go into the details of how you started your relationship in finance with any other prior business partners. So you don't need to answer that one. I think we just move to a different topic, Ms. Long.
All right. Again, Mr. Bareilles, I appreciate your willingness to try to help me along in guiding my case, but I have a very clear idea of what I want to cover today. And when you have your time crossing your witness, you can try to rehabilitate him, but please keep your objections to form or within the rules. If you think there's something that I can't ask and you want to certify that or get the judge on the phone, we can do that. I'm happy to, but at this point, your speaking objections need to stop because they're stalling out our deposition today. So let me go back to that question. You got your start, Mr. Rex, in the finance industry working for a very prominent, well, a Wall Street legend, if you will, Mr. Gladden, didn't you?
Miss, I've had many mentors during the course of my career. Mr. Gladden is just one of them.
But he was a pretty significant one, wasn't he?
He was my boss at one point.
And Mr. Gladden is known in the industry now as someone who has definitely fallen into the category of Wall Street crooks, if you will, right?
Objection, assumes facts, not an evidence, mischaracterizes testimony. Ms. Long?
Well,
we're not
okay, let
here
me
to
lay
try
that
cases.
foundation. Mr. Rex, do you know where Mr. Gladden is today?
Objection. Ms. Long, you know this is clearly not relevant. Mr. Rex, I would instruct you not to answer that question. Let's just move on.
Again, I'm entitled to ask what is within the scope. This is within the scope. If you have a problem, please go ahead and tell me you want to get the judge on the line. Mr. Rex, are you going to follow your lawyer's advice?
Judge Hoffman to the rescue. So here, I'm going to go ahead and start the panel discussion, okay? Great job, guys. Mr. Reed, if you want to join us on the panel discussion. I think this raises a lot of great questions here. We have some topics we want to discuss. We're already running a little bit behind, but we're doing a great job for both sides. First off, what we were trying to illustrate here, I think, was a situation where you have an attorney who's interrupting, who's being obstructionist. First off, Heather, why don't you kind of talk to us about what are some things that you think as a young lawyer and as a female lawyer that you've seen, and kind of how do you deal with it when you know that an attorney is trying to railroad you or run over you because they think that they can?
Well, and I'll say one thing. I have personally experienced the behavior with regard to young lawyers that hurry up, move along, or this isn't relevant. That's not part of it, because that is so common as a young lawyer. I get it all the time still. And I always like my opposing counsel to think I'm still a young lawyer every time. But that said, the way I deal with it is I just keep turning back and say, you want to go ahead and get the judge on the phone, or I will go into the very specific rules of the jurisdiction. I'm entitled to 7 hours of deposition time, and I'll use it how I please. It's within the scope of the allegations, and I'll quote, throw out the scope of the allegations in a very succinct form. But if it gets too disruptive, I will get the judge on the phone. I think I've done that with you once, Judge Hoffman. But the biggest deal when it comes to things that are condescending and that are overtly inappropriate, which Manuel didn't do, because it's just hard to manufacture that, like, when you're not that person. But I've had a lawyer say, well, young lady, that's not a very nice word to say in this deposition, and I said, well, your client's accused of rape, so we're going to use the word rape. But when you shouldn't be so crass with your words as a lady. I will do the pregnant pause, and it's this. Okay, now that we've let your comments get really uncomfortable hanging in the air, you must have been pretty uncomfortable about that. My sympathies. Let's move back to the matter at hand. And that usually shuts down the little old lady or that type of thing. One of the things that I think you can kind of see is I came at this approaching the way I was going to planned out how I would approach that witness was not a very conventional way. And, everybody's got their style. So I was starting in the middle on purpose. Mm-hmm. And that when you do that, you have to be ready to deal with a lot of these types of move along, or that doesn't have a place here, blah, 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 blah. And you just have to keep your backbone up.
So one thing I would say about that is I'm sorry, Manuel, why don't you go ahead and speak? You were going to say something.
I was just going to say, Judge, that she actually did call my bluff at that point. I was about to say, okay, I don't think we're at a point where we need to call the judge yet. And so I was going to back off because, I know I'm not in the right to be trying to disrupt the deposition flow the way I was. So, actually making that threat, as long as you're willing to go through with it and call you, I think is an effective way to shut it down pretty easily.
And let me just kind of talk about that, because that's something as a judge that I do deal with. I took a lot of depositions when I was in private practice, and things have changed a good bit, I think, in the 16 years since my last deposition. But I have seen quite a few cases, especially during COVID, when we had more time to deal with these types of things, where people have called us. I've gotten on a number of Zoom depositions over the last couple of years. And in some ways, That's an advantage of Zoom depositions because I feel I can get a better feel for what's going on than I can if someone just calls me. But it is the type of thing that you should do if you feel like somebody really is being, I think the way Heather handled it was perfectly. You don't want to jump the gun too much, but you also, you need to be willing to do it if you need to. It shouldn't be a situation where like, there's some minor issue comes up. It should be something that's systematic and serious. And it should be kind of the last resort before just terminating the deposition and saying, okay, you've been too obstructionist here. I need to move forward. One thing I will say, and this is kind of some new information for a lot of you guys, something you could tell the partners at your firms, is that we have just, as of this week, Monday, we have a new associate judge. And so what is happening right now at the courthouse is that we have an overwhelming number of jury trials. We actually ran out of jurors on Monday because so many courts are in trial. When we're in trial, it is harder to deal with these issues, but we now have one of our two associate judge positions filled. I know in my court, if I'm in trial, I'm going to be perfectly willing to refer these types of issues, if I'm not able to do it, to my associate judge. Her name is Judge Merritt. And we're actually in the process of filling the second associate judge position, that vacancy, and hopefully that will be done in the next couple of months. So that is also something, if you call in the court and you say, hey, Judge Hoffman or Judge Moore, or whoever's on the bench, if they can't take this right now, could we talk to the associate judge? Is that okay with the judge? Don't go immediately to the associate judge because you don't know what the position of the judge is. The judge may want to get off the bench or whatever. Just inquire of the coordinator, hey, is it okay for us to go to the associate judge and get their contact information? But let's go to the next topic. Shane, how do you deal with speaking objections and witness coaching that was happening like here?
Yeah, thank you, Judge. I thought what Heather did was just a wonderful demonstration of being very calm in the deposition and not escalating what could be personal attacks against her, and then also just the speaking objections, which are clearly against the rules. So tone of voice is so important. I've got 8 steps. We don't have time to go through all of them, but George is going to send that out after this meeting so everyone can have the 8 steps. But just a couple of them are exactly what Heather did. One, be calm, and then just ignoring the bad behavior of opposing counsel and the inappropriate coaching, because we all know in the end, the last thing both lawyers want to do is interrupt Judge Hoffman, who happens to be in trial today, and say, hey, I know you're in trial, but we can't work this out. And I'm sure Judge Hoffman would tell those lawyers, y'all need to work this out. So what Heather did was great. The only thing I would add to the demo that she didn't have time to do is to say, hey, let's take a break. And you take a break and you get out in the hall and you talk with the other lawyer and go, hey, what's really going on? Do you think I'm really that inappropriate? Are you just doing this for your client? And if you respectfully listen to each other, it'll go a long way towards getting to the end goal, which is Heather being entitled to ask appropriate questions, which they all were, and the defense counsel realizing, well, my speaking objections and attacks on her aren't going to go well in the end. The third point is videotape these depositions, because that tells the whole picture as opposed to just a transcript.
Very good point about the videotaping. Emmanuel, one thing that I think would be important to talk about is how do you preserve error and ask for the basis of objections? I think Heather did a great job of that. But let's talk a little bit about how that works in Texas State Court.
Yeah, no, great point, Judge. Yeah, it's important, especially when you're getting speaking objections like that. And, it doesn't happen all that often, but I can tell you the 3 practitioners on this call have definitely been in depositions where the speaking objections are happening. And so I think it's important in Texas State Court to make sure that the record reflects you provided, you asked for the basis of an objection. If you're getting speaking objections and you want to keep it to form, they should be form objections. If you think the objections are the form objection is not valid and it's unclear, the objection that's being made is not doesn't seem to be appropriate and really is just being used as a disruptive tactic, then you can ask for the basis of the objection so that the record is clear. And you can later in point in time, especially if you're trying to get, that testimony in at trial, you can have the judge rule on, the objection, and the record clearly reflects what the basis is for the objection. So, and a lot of times too, especially if you are, again, you feel like the defending lawyer is lodging objections, not because they are actually valid objections that they want to preserve in the record, but they're really doing it as a way to disrupt your flow. Then, a good way to make them stop is to ask them for the basis of the objection, so that they have to actually think about what it is and actually lodge the objection, state the objection, and it will be reflected in the transcript, to be dealt with later with the judge.
All right, well, let's turn over to our next hypothetical here, or demonstration. We've all seen the rise of Zoom depositions. And I tend to think, I've talked to a lot of practitioners that there will definitely still be Zoom depositions in the future, even as the pandemic slows down, hopefully. And so this is an issue that is going to come up, I think, again and again, as long as we have Zoom depositions. And so in this case, it's let's pretend this deposition, instead of being in person, is over Zoom. We're going to have the Kiloton corporate representative being taken, played again by Barrett Armbruster. Manuel Bareilles is going to be taking the deposition, and Shane will be defending the deposition. And we will go ahead and turn it over to Manuel.
Great, thank you, Judge. And so the setup here, everyone, is that it's a Zoom deposition. The witness is, appearing by video. And sometimes I've actually been in a deposition where the defending lawyer is also in a totally different city, and is also appearing, by video through Zoom. Here, for purposes of this example, we're going to have the defending lawyer, Mr. Reed, was going to be in the room, but Shane, if you'll turn off your camera, I'd like it so that I can't see you, and there's only one camera in front of the witness, and so you're just in the room but not on camera. All right. Mr. Armbruster, where are you physically joining us today for your deposition?
I'm in my lawyer's office.
Okay, and your lawyer is in the room with you, correct?
Yes.
Now, I can't see him because there's only one camera and it's focused on you, but is he sitting to your left or right?
He's sitting to my right.
Okay. You obviously have a computer screen open in front of you for this Zoom deposition, but do you have any other computer monitors or device screens that are accessible to you in the conference room?
I have my phone and my monitor to my left here.
And is that a second monitor in addition to the computer screen you're looking at where your camera is?
Yes.
Okay. Is there anything on that, showing on that second monitor this morning while we're getting started?
No.
Okay. Your phone, you said you have, is your phone available to view while you're answering my questions?
No.
Okay. You understand, sir, that the testimony you're giving today is under oath, just as though you were sitting in a courtroom with a judge and jury present, correct?
Yes.
So if we were in a courtroom, you would not be allowed to consult, for example, with your lawyer before answering a question, correct?
Correct.
And you also would not be allowed to consult or read or review any documents that I haven't provided to you before you answered a question. Is that right?
Sure.
Okay. Let me ask you this. Will you agree that for today's deposition, unless I've shown you a document and shared it with you over Zoom, you will not consult any other materials that are accessible to you? Can we agree on that?
Sure, but I did print out some emails and articles that my lawyer said you would ask about. Is that okay?
Well, that's fine. Are those papers in the room with you? Those printouts?
Yeah, I've got a binder.
And the binder is there with you?
Yep.
Okay. Did you write anything down on those printouts? Maybe some notes or questions or markings?
No notes.
Okay. All right, I'm going to push pause on the demo real quick, and now let's assume we've gone through some topics, and we're I don't know a couple hours into the deposition, and so we'll continue with the demonstration now. All right, thanks for we're just coming off a break. Thank you for being patient with me as we've gotten through these issues. Just as a reminder, Mr. Armbruster, you've been designated by Kiloton as the corporate representative for the topics we've been discussing today, correct?
Correct.
And one of those topics relates to Kiloton's allegation about that the season finale of And Thus and Ms. Cadshaw's subsequent Instagram post, that those things caused Kiloton's stock price to plunge. And I think the allegation is, the business was destroyed, correct? You're here to testify on those topics.
Correct.
Okay. You're also aware that long before that season finale, Kiloton's earnings had already decreased by 60% from 2020 to 2021, correct?
That sounds right, but the company's stock really plunged after the episode aired. And I believe that Ms. Cadshaw's Kiloton Kills post went viral, and that's when the stock dropped 39%.
Mr. Armbruster, I have not shown you a document yet, correct?
Not since the break.
But you were just reading a document on your monitor during your answer, is that right? Mr. Armbruster, I'm not asking your lawyer to answer this question or provide you with the answer. I'm asking you whether you were just reading a document on your monitor during your last answer.
You told me to testify truthfully. I'm just trying to make sure I give you the right number for the stock price.
So the answer is yes, you were reading a document.
Yes, but it's just a timeline that I put together with some key facts and key dates.
Okay, Judge, I think we can stop there and kind of talk about both of those sort of segments in time in the depot.
Okay, so you want to turn over to the panel discussion now?
Yes, let's go to the panel discussion.
Great. Shane, if you want to, and Heather, if you want to come back on. So one of the things I think that Manuel, you did a great job with, but I think it's something a lot of people should kind of adopt is there needs to be, if we're going to do Zoom deposition, continue to do that, we need to deal with issues involving exhibits, how those are going to be handled, an agreement and how to conduct the deposition so that some of the issues that people are concerned about and that have happened. So tell us some of the things that you do, Manuel, to deal with these issues.
Sure. Yeah. So, I mean, as you can tell, I was wanting to establish at the outset who was in the room, what devices were on. I actually had a trial, a Zoom trial a couple months ago where a witness was testifying alone. The lawyer was somewhere else, but, in their home office where they had multiple monitors up. And it was very clear that the witness was looking at, something that was on a monitor, even though no exhibit was being shared through the Zoom. And so, I think it's important to just establish early on what the kind of the ground rules are, right? That the witness shouldn't be consulting any other materials or documents, and so I think it makes the conversations and discussions you might have later on in the deposition, when it appears that they maybe are consulting something, you can refer back to the ground rules that you thought everybody was on the same page about at the outset about, what can be viewed, what access to other monitors there are, who's in the room, et cetera. So, unfortunately, I think those are things that we didn't have to worry about when everybody was in the same room and we were all looking at each other. But now that you literally can have everyone in a different office, including your court reporter. I think we need to spend some time. It doesn't have to be a whole lot, but I think you will save yourself some headache down the road in the depot if you've dealt with some of those issues. You sort of add it to the list of housekeeping things that you need to deal with at the outset, including, we didn't really get into the exhibits, but the same thing about how you're sharing exhibits, what exhibits you can look like. Some witnesses might actually prefer to have a binder of potential exhibits. And you could always send that to them and they've got it in front of them and they don't have to worry about, and you don't have to worry about what's showing up on the computer screens. But I'll stop there, Judge.
Do you typically, I know there's a lot of programs, share screen obviously on Zoom, but there's other programs to allow for even more effective presentation of exhibits. Do you typically, this is really to all the panels, do you typically use share screen during the course of a Zoom deposition or any other programs that may help share exhibits?
Yes, I do. I use share screen to show exhibits. And oftentimes, well, certainly a trial, maybe not a deposition, but a trial, we might also have a trial graphics person who can, zoom in on things, do call outs, and do all that, through Zoom, through a share screen program. The Zoom one is actually, pretty good and perfectly fine for a deposition, I think. And I'm interested
Shane, what
with
about
Heather.
you?
Shane.
Yeah, I agree with Manuel completely.
Yeah, I've been using the Zoom platform. I've tried a couple others, but the Zoom share screen is generally been the most reliable as far as things not freezing and dropping and coming back. I found that just in general share screen that happens sometimes, but that's just how the technology is. But it's been very easy. The biggest problems I see is when people need to read it, they don't know how the object they're sharing is appearing scale wise on the witness's screen, and having to be able to just dialogue with the witness. Do you need that larger, smaller, in focus, turned, that type of thing?
Mm-hmm.
Let's
The other
talk.
thing-
Oh, go ahead.
Sorry, Judge. The other thing I was going to add is that, you definitely want to be careful about lobbying accusations of, misconduct on the other end of the deposition. And a related point is, you really need to be paying attention to what is happening on the screen and not with your head down in your outline or flipping through documents or trying to figure out what your next question is. If I wasn't looking at the screen, I would not have noticed Barrett, looking over, appearing to be reading something. And so, when that happens, before you just accuse someone of misconduct, you probably want to ask some foundational questions like I did. Were you reading something? Try to get a clean yes or no on that. And he admitted that he was, and then explore what it is they were looking at. I probably was a little eager when he looked over to the other direction when I asked the question, were you reading something? And it seemed like he was maybe looking for some help from his lawyer. Again, you want to be careful about unnecessarily raising the temperature and making accusations of bad faith and misconduct before you really have enough to know whether that's taking place.
So Shane, why don't you tell us I'll kind of combine a couple because we're a little bit behind. When do you make the determination on whether or not to videotape a Zoom deposition? And then when do you decide, what are some of the factors you use to decide whether or not a deposition should be in person as opposed to remotely?
Thank you, Judge. I think we should all have kind of a reset of the mindset that if the if the deposition is worth taking, it should be videotaped. The transcript just does nothing to convey the credibility or lack of credibility of a witness like a videotape deposition. And going to the Zoom, I know we can record these Zoom depositions, and let's just assume we're playing it for a mediator. Let's don't get into the issue of it all, whether it's admissible in a federal court or a state court. But having a high quality HD video from a videographer is so much more persuasive than these Zoom videos, which are low quality. There are a lot of glitches oftentimes I found when recording the depositions. And so it pays at the end, just pay a little more in the beginning to have a videoed deposition.
So Heather, how do you deal with an attorney like we had here who didn't want to be on camera? And I think we've already talked a bit about how to deal with the issue of witnesses while reading, but who appear to be reading during the deposition. How do you deal with those issues?
So my personal approach has been, you need to be on camera. If we were in person, we would all be looking at each other. It's not that I don't trust you. It's just that it helps me communicate. And I have a little bit of way I do it that just is kind of works for me is, look, I'm hearing impaired to low tones, and most of my opposing counsel are men. I rely a lot on lip reading. And so if you're off camera, I am going and you're making a question, if you're questioning your witness or you're objecting, I may not pick up on it. But I think we all need to be on camera so we can all catch visual cues of when somebody's beginning to talk or not beginning or finished with talking, so that our court reporter and the transcript comes out better. And that's kind of the way of approaching it in my mind, of not making it an adversarial issue, making it a logistical one. And I've had very little pushback. And if somebody's going to push back that hard on it, and 'cause I do all this on the record, then fine, because that tells me a lot about, hey, that might be more useful to me later anyway. And I think the difference too on needing to be in person and not, I've got a set of depositions I'm gonna be taking in a sexual assault Title IX case, and every one of those suckers are gonna be in person. But for just general depositions and cases, I think we have, there's a lot of thinking to do for everyone in their various practice areas on what their parameters for needing to go in person versus Zoom, and what's appropriate for each case or each witness.
Shane, if you could talk to us briefly about just some of the technical details involved with, external cameras, lighting, framing, whether or not you have more than one camera, all that kind of stuff. What are some things that you would suggest people look at?
Well, that's a lot. I'll shorten it down, Judge Hoffman. People who appear well and look good are more trustworthy and knowledgeable than those that don't appear well and look well. So lighting's important for your credibility. Make sure there's lighting in front of your camera, and then you just need the right equipment. I'll go through 4 things you need to have. You need to have a HD camera. Don't rely on your laptop camera to present yourself well. So it's an HD camera, and George is going to send out a little description of these products. And for about $130, you can get completely set up that will transform the way you look. So you get an HD camera. The second thing, don't rely on your computer microphone. You can get this microphone for $39. It's going to help your voice, just makes you sound a little better. The question is for lighting, and for lighting, work around your office. Before we got on today, we were all, Heather, Judge Hoffman, we were all talking about what's our lighting look like. So this is a ring light, costs about $39 on Amazon. You can place it to the side, in front of the computer, wherever the shadows are, to get rid of them, just so that you look better. And if you look better on camera, you're going to be more confident. You're going to look more credible to the witness that you're deposing. You're going to look more trustworthy to opposing counsel. And the finished product, if this is played before a jury or a mediator or whoever the decision maker is, looking better will make you be more persuasive.
Okay, so we're officially behind now. So we're going to go to the last demonstration, and that is dealing with a difficult witness, impeaching a witness with an exhibit, and forcing a witness to answer a question. The witness is going to be Barry Cadshaw. Taking the deposition will be Shane, and defending it will be Heather. And I will be breaking this up rather quickly, unfortunately, because we are almost out of time.
Thank you, Judge. And so, Barry, although we have a script, we'll shorten it to get within the time limit. So just work with me. So here's what I want to do. I want to show you the wrong way to try and get a witness to answer your question, and then the right way. And the wrong way, what we all do is we ask this ultimate question that's complicated and long. And let's do that first, and then we'll do a second demonstration with the right way to get an admission. Here's the wrong way. Mr. Cadshaw, it's true that you and your spouse who was running the hedge fund, that y'all got into an agreement and that you wanted to profit to help your new Pilates business. And the way you did that was that you had your spouse, who's in charge of this hedge fund, take a short position in Kilotron stock, And then on the final episode that you were in charge of, that you were the director, you had the main character killed by a kilotron machine. And when that happened, the stock tanked, and then your spouse was able to sell his short position and make $1.2 billion in profit. I mean, isn't that what happened?
Check to the
No.
form.
Well, let me rephrase it another way. I mean, you were desperate to make money. You had this new brand kicking off. And so your spouse takes a short position in Kilotron, you kill off the main character, and lo and behold, 2 days later, your spouse sells it for $1.2 billion in profit on the short position.
Objection to form.
No, that's not how it happened. First, my spouse never shares with me what they're doing with their investments. Two, I write these shows with a large group of people, so it doesn't just come down to me. And three, there's no proof to that any of what you just described happened.
Okay, so that's the end of this part of the hypothetical. And we can all see that if you ask this ultimate question, no one's going to admit they're a rapist or that they stole from another company or that they broke the contract that they're accused of breaching. Instead, let me give you a theme, as Heather was suggesting in her first demonstration, that will work in your next deposition. And it's the theme of the simple truth. And if you start your questions with that phrase, the simple truth, you will get the witness to admit whatever question you're asking, as long as the question's simple and you have a way to back it up. So in our next demonstration, I've got a document that's going to be able to back up my simple question, and watch how I'm able to win, even though the witness is going to dodge the question. So, Mr. Cadshaw, the truth is that your hedge fund bought a short position in Kilotron stocks and sold it just days after the episode aired, making a profit of $1.2 billion.
Well, that's my spouse's business, and he analyzes a wide variety of companies and he makes decisions based on algorithms and statistics, and I don't know anything about that.
Ms. Cadshaw, let me just repeat this simple question. The simple truth is that your spouse is in charge of a hedge fund, took a short position in Kilotron stock, sold that position just days after the last episode aired, and made $1.2 billion in profit.
What you don't understand is that my spouse runs a large financial company that is holds accountable lots of different companies for its investors. You may seek many different investment opportunities on any given day, and I don't know anything about that.
Ms. Cadshaw, do you remember in elementary school that you took true-false tests? Let me sure you
Yes,
did, right?
I remember true and false tests.
And when you were asked a true-false question, you couldn't answer with an A, B, C, D multiple choice answer, right?
Right.
And you couldn't write out a long narrative answer when the question asked for true or false, right?
Right.
All right, let me show you Exhibit 1 and look at it. And here's the question for you. The simple truth is that Cowboy Capital, according to this document in front of you from JP Morgan Chase, shows that it sold its short position on April 3rd, just 2 days after this final episode aired, making a profit of $1.2 billion.
That's what the document says.
All right, so audience out there, the reason this works is it's a simple question, and I've got a document that there's no way the witness can dispute what the document says. Now, you may disagree with my ultimate conclusion, but you can't disagree with the statement. So quickly, my last hypothetical question is, what do you do if you don't have a document? Well, then you use logical reasoning to prove this simple truth theme. So I'll speak a little quicker than normally just to get through the hypothetical. So, ma'am, it's true that you were the director and you made the final decision to kill off Mr. Big with a Kilotron machine, and that Cowboy Capital made a profit of $1.2 billion. Correct.
Let me object to the form. You can answer.
Well, it's a little more complicated than that. I have an entire writer's room that comes up with the script. So it's not just me.
Well, the simple truth is you were the director, right?
Right?
You were in charge of the plot on that last show, true?
True.
And Mr. Large was not killed by a car accident, right?
That's right.
He wasn't killed by a gun or a knife or anything else, right?
Right.
He wasn't injured,
No.
and he was killed by a kilotron machine, right?
Yes.
Okay, so that ends the hypothetical. The reason that wins is the logic is that the director is going to be in charge of the plot on the season finale of this huge show. And it's ridiculous for the director to say, well, someone else made this decision. So that's why it wins.
So we're running real late on time. Thank you so much. Great job, guys. So let me turn it over to Manuel to talk about how and whether to impeach a witness during the deposition as opposed to waiting to trial.
Yeah, great question, Judge. A lot of that will depend often on whether or not you think this witness is someone who's going to get called and testify at trial. If there's any, chance that maybe the witness doesn't make the cut for trial, or maybe the witness, there's a health reason, right? During the deposition, that may be your shot, and it may be important to go ahead and impeach the witness then. Also, if you're in civil litigation, right, and you've got a chance at a summary judgment motion, and impeaching this witness maybe helps on a dispositive fact issue that's relevant and would be decided by the judge at that stage of the case, then that would clearly factor into whether you go ahead and impeach. Then, if it's a witness who is going to be a key witness, right? It's going to be at trial. Obviously, it's way more effective to impeach that witness in front of a live jury than it is to play a videotape for the jury from the deposition. So that would be a factor for me as well. Is just the likelihood that witness is going to be testifying in front of the jury during the trial.
So if we could have maybe Shane talk about the issue of, how, when you've made your point, in the deposition, is it best to just kind of leave it with that? Or do you want to sometimes let the witness keep going with the witness and give them a chance to get a little more wiggle room?
I hate to give this answer because I hated in law school, but it depends. I think Heather and Manuel and Judge, you would all agree with me. You just have to sense the situation. And if you think you can pin down the witness by asking more questions, do it. But if you think by asking that third and fourth question, you're going to alert the witness that you've got this great admission and they're going to change their answer that you just got 2 questions earlier, don't do it. And it's just judging the witness. And that's the best answer I can give.
We didn't really talk about this, but this kind of raises an issue I've seen quite a bit lately. And then we'll end with this. Any of you guys could comment on this. I've seen a number of depositions lately where a witness has made multiple changes in their errata sheets. When is that a good idea and when is it not a good idea? And I'll let Shane answer that to start with.
I love changes in errata sheets when it's the adverse witness. I just think it's wonderful impeachment stuff at trial that, oh, now that you've had 2 weeks and you've consulted with your lawyer, you've changed your answer.
Mm-hmm.
So you want to do that very, very rarely. I had one case where there was over 100 changes to an errata sheet.
That's
that's never a good thing. So I'm going to go ahead and guys, great job. Thank you so much. I think this was really informative. I'm going to go ahead and turn it over to George for concluding remarks. Thank you so much.
Thank you, Judge.
Thank you, Judge Hoffman, and thank you to everyone on our panel for some excellent demonstrations and also for some really informative discussion. I'd also like to thank the rest of the members of the Trial Skills Bootcamp Committee for helping prepare today's presentation, especially Julie Christensen and my fellow co-chairs, Barrett Armbruster, our star witness, Monica Gaudioso, Alex Reisinger, and Nicole Plagins. The CLE course number for today's program was included in the chat. And if you enjoyed some of the points that Shane Reed was making and some excerpts to his books, were also included in the chat. Our next program will be the Trial Skills Boot Camp on Witness Examinations and Objections. It will be based on the same hypothetical as today, the excellent hypothetical prepared by Barrett about the kiloton device. So look out for the dates that will be this summer. Thank you, everyone.